Okay, so today we're going to look at strengths and weaknesses of lawmaking through the courts. I would suggest you need to know at least 4 strengths and weaknesses to make sure you're going to be able to write enough information for these type of questions. Really, you need to be able to evaluate the effectiveness of the lawmaking by the courts, and that really means being able to balance strengths and weaknesses and coming to a strong conclusion. First real strength of the courts as lawmakers is that they can change the law quickly. They can change the law quickly if a relevant case is brought before them, because they're not burdened by long parliamentary procedures as Parliament is. Once the case is before them, they can make a decision, and then the reason for that decision then creates a precedent which is then binding. However, they can only change the law if a case is actually brought before them. And this requires a person with standing to bring the issue to court, and actually can take a long time for cases to come before the courts. For instance, it took negligence almost 100 years to be developed. They can also be bound by precedent and unable to change the law, depending on where the precedent was set. Second key strength is that they're independent, particularly compared to Parliament. They're not subject to political influence when making a decision. Judges are independent and unbiased. They're not subject to the whims of the electorate. They can just make the best decision for the case at hand, rather than just doing what is popular. However, the other side is that they're not elected. So judges may not reflect current community values when making a decision. In particular, in comparison to Parliament, which we saw in Area Study 1, should be representative of the views of the majority. Judges are not in that same position. Secondly, courts can be quite flexible in lawmaking. They can keep the law from becoming too rigid by distinguishing, overruling or reversing precedent, and by interpreting statutes. They're able to apply the laws of Parliament to the specific situations that come before them to make sure that the law is relevant and that justice is served. However, again, sometimes they may be bound by precedent, or courts are quite reluctant to change the law for the sake of consistency. A big strength of the lawmaking by the courts is that they can provide consistency and fairness. The doctrine of precedent allows for the law to be applied consistently when material facts are similar, that people should know that if they go to court with a similar case than a precedent, they should get the same result. That provides predictability, equality, and fairness in the law. However, courts do make laws ex post facto. Because they make laws retrospectively or after the act has already occurred, that can be unfair if a person is found to have broken a law that didn't exist at the time. And again, that was seen in the Trigwell case. Courts are able to actually develop areas of law somewhat similarly to Parliament. Negligence is a very broad area of the law that was established by the courts and developed further as the need arose to cover things like road accidents and negligent advice now. However, they don't have the resources to investigate whole areas of law as Parliament does, and they can only deal with the area of law relevant to the case before them. So generally, Parliament is in a much better place to develop comprehensive laws. So because this you generally get an evaluate type question here, it is important to come to a strong conclusion. So you can just simply say that overall, while there are some weaknesses, the strengths outweigh them, making the courts an effective lawmaking body. And that's it.